Hi, greetings to everyone. My name is Alex Fotох. I am an attorney of the High Court of South Africa and director of Fotoh Associates Attorneys, a law firm that is based in Кейптауне, South Africa. It is an honor and a privilege for me to have been given the opportunity to speak in this conference of business people that is organized by the Belarusian Chamber of Commerce. I want to seize this opportunity to thank the organizers of the event. I also want to thank our partner, Economic Dispute LLC, a law firm that is based in Belarus, for extending the invitation to me. Let me apologize for my voice. I've been having flu for some days now, and hence the sound of my voice. I would like to choose as a subject from which to speak the ease of doing business in South Africa from a legal perspective. Let me begin by saying that for many people, South Africa is regarded as the gateway to Africa in terms of business opportunities and investment opportunities based on the stable political system that we have, an independent judiciary, the rule of law, a constitution that guarantees fundamental rights, an economy that is the most developed, most advanced, and most industrialized economy in sub-Saharan Africa, and that boasts of good infrastructures as well. For this reason and many other reasons, many people see South Africa as a preferred investment destination in the continent of Africa. Now, South Africa also has a well-established jurisprudence that have been developed by our courts for many years, in fact, centuries, that brings about legal certainty, especially in terms of ownership of property and dispute resolution that is very important for businesses. As you would know, as business people, the market does not like uncertainty. The market likes certainty. Now, Section 25 of the South African Constitution protects private ownership of property. That section says in substance that no one may be deprived of property except in terms of law of general application. No law may permit the arbitrary deprivation of property. Now, speaking about dispute resolution, most economic disputes or commercial disputes in the South African justice system will either arise or flows from the law of contract, or the law of delict, or the law of unjustified enrichment. There's 10 main provisions of South African civil legislation governing the conclusion and execution of a foreign economic contract. And now, the first thing to understand is that there's no single piece of legislation that provides for the conclusion and execution of a foreign economic contract in the South African legal system. The contract law in the South African legal system is governed by common law, and common law in South African context is Roman Dutch law. Let me say that the South African legal system is a mixed legal system comprising of Roman Dutch law, the English common law, the African customary law, and personal religious law. Now, all those laws work in sync together in harmony, and they are shaped by the South African Constitution, and in particular, the Bill of Rights in the South African Constitution. So the contract law in the South African context is governed by the Roman Dutch law, which I said is the common law in South Africa. And of course, there are certain contracts that are legislated. For example, the sale of immovable property, a land or a house, is governed by the Alienation of Land Act. So certain contracts are legislated, which are pieces of legislation passed by Parliament. And also certain aspects of international commercial transaction, international trade law, they are also legislated, like the UNCITRAL model laws and rules, convention to which South Africa is a party. UNCITRAL is a United Nations Commission on the International Trade Law. So those legislations, which are international legislation, but domesticated in the South African law are also part of the body of law that govern contracts of this nature. Perhaps the most important law to point to in this regard would be the provision of the South African Constitution, which is Section 39 sub 1. It enjoins the South African courts when interpreting and developing the common law to have regards to foreign law and international law. So that gives competence to the South African courts to, when deciding matters, to also have regards to foreign law and international law. And of course, the terms of contracts are always often the point of departure in issues emanating from the contract itself. One of those underpinning principles and rules is the freedom to contract. Parties have a right to freely contract and negotiate their own terms of the contract, and when they do so, they are bound by it, and they're bound by those terms, and the court will enforce and give effect to the terms of those contracts. That is called pacta sunt servanda. It is a Latin maxim, literally translated to mean you are bound by what you agree. So terms of contract, for example, would have a dispute resolution clause that would say which court or tribunal or forum would have jurisdiction to deal with issues emanating from the contract. It will also say which law is applicable to the contract and stuff like that. So the terms of the contract is very important and would always be the point of departure. So the second question says the structure of South African courts and their competence to hear foreign dispute. I think part of my answer to question 1 is also covered in question 2. I've talked about the Section 39 sub 1 of the South African Constitution that empowers and enjoins the court when deciding issues and when developing the common law to have regards to foreign law and international law. So that will give competence to the South African court to deal with issues of that nature, being a foreign trade dispute. And of course, foreign trade dispute will often always emanate from a contract. So again, the terms of the contract are important. The terms of the contract will confer jurisdiction on the court or tribunal that the parties agree should decide on their matters. And it will also say which laws are applicable. So South African court, of course, will have jurisdiction if those contracts, the terms empower and give jurisdiction to the South African court. And of course, like any other country, the South African courts have a hierarchy of courts. We have the magistrate court and the high court, which are courts of first instance. And we have the Supreme Court of Appeal and the Constitutional Court, which are appeal courts. Just to mention that in some cases, the Constitutional Court in South Africa can also sit as a court of first instance and can grant direct access to parties on issues that raises constitutional matters. It's only on exceptional cases. Otherwise, that court is a court of appeal. Now, the third question says 5 main steps in the enforcement of foreign judgment and arbitral decision on the territory of South Africa. Now, the enforcement of foreign judgment is also governed by common law in South Africa, and the enforcement of arbitral decision is governed by the International Arbitration Act. Now, what is important there is that foreign judgment or foreign arbitral award are not immediately and automatically enforced in South Africa. One will have to first of all make an application to the High Court for the court to recognize and enforce that foreign judgment or arbitral award. And there are some requirements that must be complied with, such as the foreign court that granted the judgment must have jurisdiction to grant that judgment. The judgment must not have been obtained by fraud. The judgment must be final and conclusive, and the judgment must respect and observe some basic natural principles of natural justice, such as audit alteram partem, which literally translates to mean hear the other side. So the person against whom such an order or judgment was made must have been given the opportunity to present their case, to defend the case, and to state their case. And also, the judgment must not be to enforce penal or revenue laws in that foreign country. So those are some of the requirements that must be complied with before a South African court can grant an order to recognize a foreign judgment, foreign arbitral award. And I must also point out that the South African courts retain the discretion to grant such an order. So it's not automatic, it's not immediate. And then the fourth question says, legal aspects that require attention to avoid losses due to bankruptcy of a South African debtor. Or bankruptcy here, insolvency is when one is unable to pay their debt and where their liabilities exceed their assets. So that's bankruptcy. And what happens there is for creditors to come together and the assets are sold and they are paid out, distributed to the creditors in certain order and in certain hierarchy. There are different kinds of creditors. You have secured creditors, you have unsecured creditors, you have preference creditors, you have concurrent creditors. Time will not permit for me to dive into all of that. But the point I want to make is that for one to prevent a situation where they avoid loss in a bankruptcy situation, one will have to be a secure creditor. That means their debt must be secured by a collateral security. So for example, if your debt is secured by a mortgage loan, if that property is sold, you get paid first and you get paid in full because that collateral security secures your debt. If you are an unsecured creditor, then the chances are that you carry the inherent risk of not being paid or maybe paid only a portion depending on the asset that are realized. And of course, the insolvency remedy is one of the many remedies that are available to a creditor to recover debt. Speaking about debt collection, there are so many other remedies. There's what we call attachment of the emolument or emolument attachment order. The salary of the debtor can be attached and the employer will be ordered to deduct a certain amount from their salary and pay over to the creditor. There's also what we call the Section 65 procedure, whereby the debtor is brought to court and the court conducts a financial inquiry on their affair to establish a financial position. So there's so many other recourse and remedies that are available for debt collection purposes to a creditor to recover debt from a debtor. Insolvency or bankruptcy is just one of the many. Money. I think that brings. Now, I just want to touch on arbitration. It has become some sort of like a permanent feature now in the world of commerce that parties include arbitration clause in their contract, and where there is a dispute arising from the contract, the parties will refer the dispute to an arbitrator. The advantage of arbitration is that arbitration proceedings get concluded or finalized quicker than in the court system. And where there is an arbitration award that is granted in terms of the South African legal system, that arbitration award must be made an order of court before it can be enforced. Now that takes me to debt collection procedure in the South African justice system. A creditor who has a judgment can enforce that judgment in so many ways. The creditor can instruct a sheriff, who is a messenger of the court, to attach the properties of the debtor, sells them in execution, that is on auction, and whatever money that is realized, pay them to the creditor. Where the debtor is bankrupt, insolvent, cannot pay their debt, the creditor can sequestrate or liquidate the debtor, and the properties of the debtor will be sold on auction, and the money is paid to the creditor. Now, this jurisprudence that I'm talking about does not only apply to transaction of business between South African companies, it applies also to transaction of business between South African companies and foreign companies, where there is a contract that has an arbitration clause and says that arbitration will take place in South Africa and says the applicable law will be South Africa, then the same jurisprudence I've talked about will also apply. And like I said, the economic dispute or commercial dispute can flow from either one of the three areas I've talked about. Can flow from the law of contract, can flow from the law of dealing, or from the law of unjustified enrichment. Now, given the time limit that I have of 15 minutes for this presentation, I cannot dive into detail of all these aspects that I've talked about. I cannot also cover all the legal aspects of doing business in South Africa. But I want to conclude my presentation by saying that the South African courts are competent to deal with economic dispute or commercial disputes arising either between South African companies or between South African companies and foreign companies. Our judiciary is independent, and we have an established jurisprudence that provides legal certainty on ownership of property, dispute resolutions, which is important for businesses. Now, I want to thank you for listening, and I wish you the very best for the rest of the conference. I thank you all.